It's a common practice in recent years to say certain media was fake news. Donald Trump didn't invent that expression, he perfected it in his campaigns, but the real fake news that was growing up was a National Enquirer. Ironically, National Enquirer was more of a newspaper later on, but he would make up stories and speculation in all categories: entertainment, news, politics. But a lawsuit that almost bankrupted him involved America's female sweetheart. The as big as Lucille Ball was, this woman was just as big. So today we're talking about maybe one of the most important entertainment libel cases of the modern era: Carol Burnett versus National Enquirer Incorporated. Now this was decided on July 18th, 1983, and the case opinion has been made precedent since then. Now, the Carol Burnett versus National Enquirer Incorporated was a decision by the California Court of Appeal, which ruled that the actual malice required under California law for imposition of punitive damages is distinct from the actual malice required by New York Times versus Sullivan to be liable for defaming a public figure, and the National Enquirer is not a newspaper for the purposes of California libel law. Now, in 1976, the leading U.S. gossip tabloid, or fake news, newspaper, the National Enquirer, published a brief column incorrectly implying that actress-comedian Carol Burnett had been drunk and boisterous in a nightclub encounter with U.S. Secretary of State Henry Kissinger. Burnett, a passionate campaigner against alcoholism because it impacted her family, sued the Enquirer for libel persistently over several years, ultimately settling out of court for a reported $200,000, though offering no witnesses to its defense. Initially, the Enquirer argued that it was exempt from liability on legal grounds, particularly on grounds arising from the First Amendment to the United States Constitution. Initially, Burnett sought $10 million, but her attorney sued in California courts for $1.6 million, which a jury awarded Burnett in actual and punitive damages. However, the presiding court cut the award, and in subsequent appeals, the award was reduced to $200,000, though the final settlement was out of court. The main reason was the value of the lawsuit was bigger than the value of the Enquirer. It wasn't a big money maker, it was more a troublemaker. The case was widely regarded as a watershed event in tabloid journalism, and some analysts suggested it may have increased celebrities' willingness to sue tabloids for libel and dampen tabloids' recklessness in reporting, though others contended did little to reduce the profitable industry's flouting of the laws against libel. Now, under British common law in the UK and Canada, it's much different, but the States, because it doesn't follow the British system, it's more leeway. Now, in the facts of the case, it was quite interesting, and I followed this from start to finish. In January 76, Burnett was dining at the Live Gauche restaurant in Georgetown, Washington. She drank 2 or 3 glasses of wine, but was not drunk. She exchanged parts of her dessert, a chocolate souffle, with diners at a couple of neighboring tables after they became curious about it. Later, as she was leaving the restaurant, she was introduced to Kissinger, who was also dining in the restaurant. In March of that year, the Enquirer published a short item about the incident: Carol Burnett and Henry K. in a row. It read in its entirety: in a Washington restaurant, a boisterous Carol Burnett had a loud argument with another diner, Henry Kissinger. Then she traipsed around the place, offering everyone a bite of her dessert. But Carol rarely raised eyebrows when she accidentally knocked a glass of wine over one diner and started giggling instead of apologizing. The guy wasn't amused and accidentally spilled a glass of water over Carol's dress. Now, none of this occurred. Now, at the time, she was still the host of a very popular Carol Burnett show and basically was an actress on TV and movie of Summer Now. Now, California law specifies that a newspaper is protected from all non-economic damages for libel if it publishes a retraction equally conspicuous to original offending article. The Enquirer published a short retraction in April 76. An item in the column on March 2nd erroneously reported that Carol Burnett had an argument with Henry Kissinger at a Washington restaurant and became boisterous, disturbing other guests. We understand these events did not occur, and we are sorry for any embarrassment or report that may have caused Miss Burnett. Of course, it proved unsatisfactory to America's sweetheart. She then went on to sue the Enquirer for libel in LA Superior Court, because Burnett was judged to be a public figure, which I am as well. So if you defame me in public, I will sue you. Under the stand of New York Times Company versus Sullivan, she was required to prove actual malice that the defendant, which published the item, knew that was false or had reckless disregard for whether it was true or false by clear and convincing evidence. Now, in this case, they were trying to ride on Burnett's fame to gain sales of their newspaper to a public maybe that did not like her, thus committing more profit for said publication than would be if they didn't report her. Now, again, she had she was required to prove actual malice that the defendant, which published the item, knew was false or had reckless disregard for whether it was true or false by clear and convincing evidence, hard to prove. During the trial, it became apparent that Enquirer had published a story on the basis of the account of a paid informant, Curry Hayes, who had told Enquirer that Burnett had taken her souffle around the restaurant in a boisterous manner, but she was emphatically not drunk. He had not said anything about Kissinger. An Enquirer reporter had attempted to verify the story, but had discovered nothing other than Burnett had shared her souffle and had conversed with Kissinger. Again, they blew it up, and the story was published. California law specifies that punitive damages can be awarded only if an item is published with actual malice, which is defined in a state of mind arising from hatred or ill will towards the plaintiff, providing, however, that such a state of mind occasioned by a good faith belief on the part of the defendant in the truth of the libelous publication or broadcast at the time it is published or broadcast shall not constitute actual malice. The trial court instructed the jury that it had to find the actual malice as defined in California state law by a preponderance of the evidence to award punitive damages. Now, to set up a jury is like Donald Trump, right? You're going to find people that hate him and people that love him, and either one can serve in a jury because they're taking sides. It was very hard to find a jury on this. However, the jury that was chosen awarded Burnett $300,000 compensatory damages and $1.3 million in punitive damages. The trial court reduced this to $50,000 compensatory damages and $750,000 in punitive damages. Now, the Enquirer did appeal on 4 grounds: that the jury had been incorrectly instructed on the grounds on which it could award punitive damages, specifically that it should have been required to find actual malice, as defined in California state law by clear and convincing evidence, that it should have been protected from non-economic damages because it published a retraction. The members of the jury pool had been tainted because they were exposed to a tirade by Johnny Carson against the Enquirer, that the punitive damages were excessive. Of course, the Enquirer had it out for Johnny for years. Now, the Court of Appeal ruled against the Enquirer in its first 3 arguments. The court distinguishes the standard of actual malice defined by New York Times versus Sullivan, which had proved by clear and convincing evidence, from that required by California state law for the imposition of punitive damages, which has to be established only by a preponderance of the evidence. In addition, the court found that the Enquirer did not qualify as a newspaper under California libel law, and so was protected by the fact that it issued a retraction. The terminology at the time was dirt sheet. Now, the court, however, found for the Enquirer in his final argument, he found that the award was nearly 35% of the net value of the Enquirer and reduced the punitive damages to $150,000. So they were going to fine the Enquirer, but they didn't want him out of business. Now, that is a little bit different. There's been different libel cases, which has led to the destruction of different media. Depends case by case. Now, there's many people that were raked over the coals here. Rock Hudson, John Wayne, Clint Eastwood, Lee Marvin because of the palimony case, various young celebrities, Tom Cruise, Jennifer Lopez through the year. But the National Enquirer at one point, ladies and gentlemen, they were probably the biggest circulation. I give an example. They call that tabloid news, right? You could not pass a checkout counter in Canada or States and not see the National Enquirer or different magazines in Canada, Chatelaine or Good Housekeeping. You would never see Sports Illustrated. National Enquirer was every place. And the idea, ladies and gentlemen, Star Magazine and all these different ones, it became within 15 or 20 years, they became less effective. Now, the National Enquirer at the time, ladies and gentlemen, I could be wrong, I think they were all a black and white publication. The only changes they did over the years was towards color because you would have that, what I call the information, informed sources say. But Carol Burnett, she's a tough nut. And she went through a lot through the years with family upheaval and different stuff like that, trying to find a way after her show was canceled, which was probably the biggest in the world at one point internationally. So was Carol Burnett the right to sue? Yes. Was the National Enquirer right to say maybe she was a little bit freaky and sharing a meal? Yes. Did he need to make up stuff to embellish the story? No. In the 55,000 stories I've ever done, the only embellishment I would do is predictions in my movie, TV, and sports column, as to say, well, Montreal got a good team this year, they probably win the Cup. Or that new Tarantino movie is good, it might win a Best Picture Oscar. Or the new Bob Newhart show or Bill Cosby show might be enough to win an Emmy. That's speculation, that's maybe not come true, but it's not a negative connotation. Saying, oh, you know what, that's a popular team or a popular story or a popular show or a popular actor, they're probably going to be recognized like they did in the past, like Jodie Foster. Every Florida thing she touches, there's going to be a award to it. But ladies and gentlemen, at the time, this is a parallel universe. There was a time there was no internet. And you got all your gossip in the National Enquirer. That was on the newsstands, I think it was weekly or every 2 weeks. So you can imagine, every time there were people passing, it was there on a Monday, there on a Tuesday. If you don't go on the internet, a lot of people still are not going on the internet. You don't go to the rag sheets. You just go to Facebook, share pictures and stuff. It was a heady time. But would the publishing universe have been better with no National Enquirer? Not for me to say, because parody magazines like Cracked and Mad, it could have opened up problems for them because of parody. They're basically doing artwork or what you call name change parody in a comedic fashion geared towards young at heart adults or youngsters. Who knows? Mad Magazine might have got sued. Who knows? So, ladies and gentlemen, if you like what we're doing here, we're what do you call historical media podcast. Let us know in a like, comment, subscribe, or share.